All rise.
All right, good morning again, and we are here for our third case, which is 24-0997, Fernandez v. American Multi-Cinema. Both counsel ready to proceed? All right. Again, counsel, 5 minutes is the default for rebuttal. Is that sufficient?
Yes, Your Honor.
All right, please proceed.
Thank you very much. May it please the court. My name is Andrew Harris on behalf of the plaintiff appellant. Not a constructive notice case here after the two arguments this morning. The central question presented on appeal is whether the trial court erred in allowing the cross-examination of the plaintiff's treating physician regarding the fact that a trial judge, in this case I call the Salazar case, had concluded that he had given false testimony under oath. For four different reasons, it's our contention that the trial court erred and that it was the defendant's unable to establish.
I don't know. I thought you made a really compelling argument that this was error. Okay, I didn't find the fact that the order had been vacated compelling, but I just don't see the trial court's finding of dishonesty as listed in 609 or 610. It's just not in there. Maybe it should be, it's not. So can you just start with the harmless error issue? Because I think the appellee's argument as to harmless error, I think they made some compelling points. You know, the doctor testified primarily on causation, and the jury found in your favor on causation. So how can the error be harmful if the issue he testified on you won?
So the first things first is the burden is the other way. It's not my burden.
I know, but I just tell you an argument as to why the burden is met. I agree, it's their burden. You've got me there. I agree, it's their burden. But that argument being made that, hey, how can it be an error if they won the issue he testified on? How does that not meet the burden?
Sure, Your Honor. The fact that the jury found causation of an injury does not get to the issue of harmlessness or harmfulness, because the treating physician's testimony was based on the causation. He had a surgery performed, for example, Dr. Rausch, $71,000 for a past surgery. This, when a jury hears this is a finding of a trial judge that you've given false testimony under oath, and it wasn't isolated. The whole question was read out. It was mentioned twice in closing argument, and you go, well, just because we got past question one, causation of an injury, that arguably wasn't even related to Dr. Rausch at all. That was, they fought heavily on whether there was negligence at the movie theater. They found that they awarded $5,000 for past meds, $5,000 for non-economic damages under the special test, that there's no reasonable possibility that this testimony contributed to the verdict. I would submit that the defendant is unable to establish that here. You take a look at, it's the nature of, this is not just like one of the cases that I studied from the 4th District, the Strasser case. And that was where there was deposition testimony of a star witness lying under oath. We don't know the nature of that, what the lie was. But here it's one step further. This is a finding that a trial judge has found that a witness treating physician.
I get it. That goes to whether it's an error, right? I'm asking about harmfulness of the error.
Well, that goes to the harmfulness because of the credibility of that witness regarding what? The nature of the injuries. Dr. Rausch testified that there's a permanent injury, for example. Dr. Rausch testified.
So on that point, so his test, where that would come in is kind of the before and after. Like how much of this injury was caused by or resulted from the fall, right?
Yes. And
one thing that struck me about his testimony was that he didn't purport to have any personal knowledge of the before condition. He just read the medical records, right? He didn't examine any of the tests himself. He didn't look at the MRIs. He didn't purport to. And so as to the before and after, he was just reading from the records that the jury had themselves. His credibility wasn't really an issue for how much the condition changed, because he didn't purport to have any knowledge of how much it changed beyond reading what the jury itself could read, right?
That's fair, but the jury, of course, is given an aggravation of a pre-existing injury condition. And so Dr. Rausch, from the plaintiff's perspective, and this is for a jury, you don't need to have testimony. Now, that's fair impeachment, that's fair, they're experts, but from an aggravation of a pre-existing
But
condition,
aggravation goes to how much it was damaged before versus after, right?
well, I mean, by definition,
How much worse did it get as a result of the fall?
correct.
And so that's a result of a comparison between the before and the after.
Not, I would just say not entirely, because from a plaintiff's perspective, the purpose of the aggravation condition says, even if you had that condition before, right? You have,
But it had to get worse, right?
well, it has to,
Okay, so and how worse it is after the accident or the fall is based on what it was before and what it is after and the delta between those two things, right?
yes, I mean, but when you boil it down to that, I understand that, but the fact that a witness is only testifying, well, this incident is caused the need for what? For the surgery I performed. If a jury, you have this devastating impeachment, the jury could have entirely and it's not our burden, but for putting aside the burden, the jury could have discounted.
You have to keep it, it's their burden, I stipulate.
The jury could have just discounted Dr. Roush and said, we're not awarding for any of it. Because he's a liar. A judge has found that he testified in a row. That surgery is what? Unrelated. We're not awarding any damages for that. So
But
that's
they
like
didn't do, counsel, they didn't do that here, though. They found that that there was negligence, causation, and then they did award damages.
they did award $5,000 in past medical damages. And it's not our burden to have had an itemized verdict, right? There's no suggestion of that under any scenario, right? I'm sorry, Aaron, go.
But Judge Mize's point is well taken, where you won at below, and if this is your, witness going towards causation and negligence, understanding it's an aggravation case, what is it that you're saying that this testimony then led to harmful error?
I would respectfully say that we didn't win, though, because the jury is awarded, if the jury had awarded $112,000 of past meds and there may be a tougher analysis here in terms of putting on me, how do I show harm? If the jury had awarded Dr. Roush some portion of his medical bill here, we don't have any indication of that. So $5,000 most likely didn't include his surgery at all, didn't include his treatment at all. It included what happened. You had an accident, you go to the doctor, you injections or whatever. And so the most likely scenario is that the jury didn't award anything for Dr. Roush. I would say by definition, that makes it.
But aren't they instructed you alone can assess the reasonability of how much damages should be awarded, and they in fact awarded 10,000?
Well, 5,000 for past med and 5,000 for past non-economics. Yes, Your Honor, but that doesn't go to the harm. To me, that just amplifies the harm. The fact that the jury didn't award a meaningful amount of past meds, awarded nothing for the future at all, because you have a witness with this devastating effect. And that's why I know it only goes to, you say whether the issue of whether there was harm, but you do have to look at the nature of what that testimony is. That is, and from my perspective, relevant to the harmless error.
But I'm interested in the nature, right? Because
Interested in what? I'm sorry.
I'm interested in the nature of his testimony, right? Because the nature of his testimony for all of the before condition was just to relay just to relay what's in the medical records that the jury had, and to relay things the plaintiffs told him. Nothing about the before testimony relied on his credibility. He didn't purport to have any knowledge of it. He didn't even pretend he had knowledge of it, which is fine. He just didn't. That's just not something he purported to do. And so his credit as to the before and after, he had no credibility to be at issue on before and after, because he didn't purport to have any knowledge of the before. He didn't purport to have any knowledge of the change from between before and after. Am I wrong?
You're not wrong in terms of the after, but to focus on the fact that his testimony is on the after, the jury very well awarded none of the after because of the because the jury heard that he gave false testimony under oath, and they actually had this, so there
was a lot of other testimony as to the after part. His testimony only concerned, at least as far as his credibility is concerned, because that's the only part he wasn't just relaying other people's thoughts, was what was the condition of the neck after the accident, right? A lot of other testimony about that, right?
Yes, Your Honor, but
like a bunch of people.
Yes, but this is exactly what the Supreme Court. It's by coincidence I had the special case in this is exactly what the
You argue special?
I didn't argue it, I briefed it. My boss at the time argued special, but that was an issue that was percolating in the DCAs for 15 years. And I can distinctly remember and saying that this is not a pro plaintiff, this is not a pro plaintiff, this is not a pro defendant, but the Supreme Court, they declared no reasonable possibility that this contributed at all to the verdict. So by definition, if the jury may have awarded $10,000 for that surgery, that is by definition entitlement to a new trial.
Well, let me ask you this. So what would the cutoff be? Say there were, if he was the only witness who testified as to the before, you'd see one end of the spectrum. Say there were 50 and he was just one. And the jury just didn't believe any of the 50. Would we still say, well, he might have been the one to push him over the edge? I'm just, how do you define that? Is what I'm saying. How do you look at that spectrum?
We don't know. If you had a car accident case and you had 50 witnesses and the issue was only who caused the accident, and you had 50 witnesses and one of those 50 witnesses came in evidence that they had given false testimony in their oath. I think this court could say, well, you had 49 witnesses who said the light was red. And this one, the 50th witness who said it was red, a court probably wouldn't allow 50 witnesses for cumulative.
Maybe they were in for 50 different reasons, but they all happen to touch on that in their testimony, right? You wouldn't call 50 witnesses just to say the light was red, but maybe they had 50 different perspectives, right? For whatever reason, they had 50 different people. All 50 said the light was red. Jury finds light's green. One of those witnesses was found by court to be a liar. Would we say that was harmful? Because, well, they might have believed that 50th one.
I think under that scenario, you could find there's no reasonable possibility that 1/50th contributed to the verdict.
Correct. So you agree there is an amount of testimony you would reach and a number of witnesses where you would say, this one extra witness, we can be confident beyond a reasonable doubt did not make a difference on that jury finding.
Right. There comes a point where the harmless error
You just
test
don't
can
think
be
we
met.
reached that point.
No, because we don't have an itemized verdict here. We don't have an award of medical damages. We have this nominal,
What we have is the jury just wholly rejecting the notion that there was a significant harm as a result of this accident.
Fair. And a reasonable jury in a retrial could determine that, but that is not the stuff of the harmless error analysis. I readily conceded in the initial brief. They have very strong defenses here. They had their experts. This is a very defensible case. We could have 5 future juries reach the same result, but
I guess what I'm saying is you agree, you conceded there's a spectrum, right? Which I appreciate. How far do you have to go on the spectrum? Do you have to have 10 other witnesses, 5 other witnesses, 3 other witnesses? You conceded 50 is enough. How many is enough?
Well, this is not a situation like the car accident case. This is a specific doctor who's testifying. I performed this surgery. It's related to the accident. I think we have a pretty good assessment. The jury did not award for that surgery. If the jury if we had some semblance.
Did anyone other than Dr. Roush testify that this was a reasonable and necessary surgery for your client?
I don't know that offhand. I don't know offhand. I know there was other medical causation testimony, but it was not 49. I'll check that. And when I come back and rebuttal, there were not 6 other. First of all, he's the one who performed the surgery. It wasn't like his co-surgeon or whatever, testified about that surgery. And so even if there's other causation testimony from the plaintiff's treating physicians, if we're just focused on the harmless error test, this surgery, the jury may have found that this surgery was related to the accident, but for the devastating impeachment. I think that's a reasonable. There's lots of other reasons.
Did any other witness testify that, I'll just use the ballpark, 71,000 was the reasonable amount for the surgery other than Dr. Roush?
I don't think so. I don't think so. But this would be a much harder case. I don't think I would be here if the jury had awarded $112,000 in past meds and some amount in future meds. Then we're getting into, well, maybe the jury would have awarded $1 million. Maybe it becomes
a record where that 5,000 came from. That's just a number the jury picked up on their own. Was there something in the evidence that would have made them latch on the $5,000 figure?
I did not parse if that's like the initial 2 weeks of bill. That part, I didn't make that connection. There are times where verdicts are right down, they excluded, that kind of like it jumps out of the page. Probably a reflection of a jury compromise of some type regarding. But what we do have I think a pretty good assessment is that the jury did not award for Dr. Roush. And so that is where the harmless error test, from my perspective,
Was he the only witness that testified to future pain and suffering?
I don't think so. I think the plaintiff had another treating physician who testified as to future pain and suffering,
Okay. Was there
or
any,
the nature of the future, condition. Yeah.
what about any other evidence to negate that there was no need for future costs or treatment?
Well, certainly the defense had their experts who testified to that.
Okay, so there is okay.
Yeah, absolutely. And that's if we were in a pre-special world and there was some, I know it's not about the burden or whatever, but this is exactly where to go. The defense had strong defenses to make in this case, but that does not establish harmless error.
So you had at least one witness testifying for future pain and suffering, and then there was, so in theory, could, to Judge Mize's point, supplement or complement Dr. Rausch's testimony, right?
Right. I think that's a fair assessment. Yeah, I think that's accurate. But the fact that there's another witness, and I think the case law, the fact that you have another witness, I mean, there is some case law which talks about cumulativeness, right? And the special and not the conflict in the case law, but the conundrum or whatever, where you have, if you have cumulative testimony, is a trial court's error regarding one, does that now satisfy the special test? And in a car accident situation where you have a concrete issue like that of liability, I just think here that I understand when I say parsing that you're doing, I don't mean that disrespectfully or whatever, that's your job to do, but it jumps out on the $5,000 jury award. By definition, that's where the harmless error test crumbles, because the jury, they had lots of other reasons, but one of those fair reasons why they rejected is because they found the plaintiff's treating physician to be a liar and having given false testimony under oath. And so I don't presume that it was error, but if we presume for the moment that that was error, the trial court erred in admitting that, the harmless error test has not been.
Hypothetically speaking, how do we know that the jury rejected Dr. Rausch's testimony completely? Because again, there's the liability, there's a causation, and then there's a damage aspect to it. If we were to believe, okay, the jury believed him as to negligence and causation, questionable as to damages, how would we deal with that?
We don't know, but that is what the Supreme Court said, is that's not the analysis that we're supposed to do. It's not, I as the appellant or whatever, if I'm able to establish error that was introduced by the opponent, that's the opposite of the harmless error test, to go, well, maybe the jury didn't reject Dr. Rausch. Maybe there were other reasons. There could have been very good faith. Well, I mean, the jury's always in good faith, they speak, but lots of other strong defenses that the defendant had. And maybe the jury just felt the pre-existing injury, or he wasn't, or she wasn't really injured, or she didn't need, there wasn't a need for future. Those are all colorable defenses to make in front of a jury. But we never had the opportunity at that fair trial in the first place because of this devastating impeachment. And they're unable to establish, any reasonable possibility, they have to establish no reasonable possibility.
And the questioning just took place over basically like 2 pages and then mentioned once in closing. Is that right?
That's correct. It was mentioned twice in closing, back to back. But it
was interrupted by an objection and then
repeated,
completed,
and then
right?
and then the phrase again, right? That the court said and noted for the record. Fair enough. The other,
that was the extent it was brought up.
That is the extent that it was brought up. If I can just, and I know I'm eating my time, the trial court before trial said, well, this will just be one question. Has there ever been false testimony? And he'll just answer yes, and that'll be it. The problem is, and that goes to the nature of the vacated order, is that Dr. Rausch truthfully answered, no, this is a vacated order, which is void. So it was not just an isolated question. It then led to opposing counsel reading the entire discussion from a vacated order from a trial judge, which was a non-evidentiary hearing, mind you, after trial, which the third DCA vacated that order in full to reinstate the verdict. And so I understand you may the strongest part you may feel is not the part that it's vacated, but at bottom, this is a void order, which never existed in the eyes of the law. It had no place in this trial. and the defendant is unable to establish under the harmless error test. I see I'm way into my rebuttal, I think. Thank you all very much. Yeah.
Counsel?
May it please the court, Jack Ryder on behalf of the Appellee American Multi-Cinema. I'll briefly discuss the issue of whether or not it was in fact erroneous. I believe that
Is the trial court's finding that somebody was dishonest, is that one of the types of permissible character evidence listed in 9609 or 96?
dishonesty is not.
All right.
It is not. But I would respectfully submit that this can also be interpreted to go to bias. And I do submit
How?
How?
Here's how. When you have a doctor who acknowledges that he has I guess either a letter of protection or is waiting for a verdict in order to recover his medical bills, which Dr. Rausch did admit, I think it was $71,000. When he acknowledges that he has testified for the law firm before and will expect to do so in the future, when he has in the past.
All those things go to bias. Why, we're talking about the finding of dishonesty.
Sure, and I think specifically, it was the fact that he has a motive in order to provide testimony that is helpful to the plaintiff and had done so in the past and was found to have been dishonest in doing so. Well, he was found to be dishonest in the past, but he has a motive to give testimony in favor of this plaintiff.
So in other words, you're saying all doctors who are owed bills and testify are biased, right? But this guy had evidence he was willing to lie for his bias.
I believe that that is what the trial court was thinking, and I believe that is a discretionary decision by the trial judge. And again, when one looks at when the
Counsel, I'm sorry, I just want to make sure that
Sure.
I'm understanding what the record shows. I'll refer to the prior order.
yes, sir.
In the case involving the prior order, was the plaintiff's counsel in that case the same as the plaintiff's counsel in this case?
No, I didn't, and I don't believe so, and I wasn't suggesting that.
Was the plaintiff in the case involving the prior order the same plaintiff
No.
as in this case?
It was not.
But I guess what you're saying is the actual bias items you mentioned apply to every doctor owed a bill, right? And so what you're saying is that well, this showed he was willing to lie for his bias, which that's evidence of character.
I understand, Your Honor, but my point is that I do believe that the inquiry to the extent it was provided here, which was limited, is a lot like I believe it was the Farrell case. And at the end of the day, and I understand the court's point, and to be fair, I would submit that it's a close call, but that it's a discretionary call. And so the point here is from the extent of this court's standard of review in terms of this deference to the trial court on this limited issue. But I'm going to turn to the more.
Sure, I understand what you said.
Sure.
It's not a close call under 9609 and 9610.
Not referring to,
Okay.
correct,
So you think it's a close call as to whether this can be wedged into bias?
correct. And I believe that in the scope of that close call, deference can be given or should be given to the trial court. But I'm going to turn now to what I think Your Honor hit on, which I think is, quite frankly, a clear basis for affirming here. And that is the fact that here, this is simply not a harmful error. And when we look at the context of Special versus West Boca, and I recognize the law says that there has to be no reasonable possibility that it contributed to the verdict, but that doesn't mean it's an impossible standard. In Parsons versus Culp, not this court, but still, of course, informative for this court, the Second District explained that the Special versus West Boca standard is not to impose a nearly impossible standard. The court should still examine the record in its entirety to determine whether or not there's other evidence to support what the jury came down with. And here, the court should examine the entirety of the record and not just look at.
Can you point us to the specific evidence that would go to support a jury finding of $0 for future pain and suffering?
Well, absolutely. I mean, the evidence here, I think, quite frankly, is overwhelming, and here's why. You've got the fact that Dr. Rausch talked about, and this has nothing to do with the Salazar order, right? So, for example, first of all, it's a matter of credibility. So the jury is evaluating the plaintiff's credibility. And when it came to the issue of future causation, let me start by noting that plaintiff's own treating physician, who was his primary care surgeon, Dr. Melendez, I believe was his name, he testified that he saw no need for future surgery. That he looked at, and as your honors saw from the briefing, we presented testimony from multiple doctors, including plaintiff's own physician, and they all looked at the before and after MRIs, and each one of them acknowledged that there were no changes, none. There was no difference, and the evidence was overwhelming that the plaintiff.
Counsel, I'm sorry, I want to make sure I'm understanding your argument there. The witness you just spoke about, who was that, Dr.?
I believe it's Melendez. That's the
Did
plaintiff.
Dr. Melendez testify that Dr. Rausch's surgery was not reasonable and necessary?
No, I don't believe that there was even discussion about that. I don't believe so. But what he did say was that it was his interpretation. And this is in response to Judge Kamoutsis's question. The idea is, what is the evidence to support a jury finding? And the evidence to support a jury finding was the overwhelming evidence from other doctors, including, by the way, Dr. Rausch, who, when confronted with the fact that he had not looked at the before images, that he said he would defer to the other doctors who each did look at the before and after MRIs and testified unequivocally that they saw no changes whatsoever to the cervical spine in the plaintiff. And that was,
In other words, if the jury just rejects the idea that there was a change between before and after, then whatever was necessary after was not related to the fall.
Exactly. And that's a question for the jury. The jury, this is not a case, and this goes back to the colloquy between.
I'm sorry, Counsel, let me follow up on your answer to Judge Mize's question. So are you saying that Dr. Rausch on one hand testified, I needed to do this surgery because of this accident, and then said, no, I really didn't?
No, Your Honor,
Okay.
I wasn't talking about Dr. Rausch.
Okay.
Let me restate what I was saying to make sure I'm being clear. Dr. Rausch saw the plaintiff, did not know about his history, described him as having no cervical symptoms at all, and said that he deduced, based upon his evaluation of the plaintiff, that the plaintiff needed surgery. Acknowledging that he was unaware, he testified that plaintiff was asymptomatic before the fall. Dr. Rausch said that the plaintiff indicated he had instant pain at the time of the fall, which was inconsistent with the record at 1495, when the plaintiff said he did not have neck pain at the time of the fall. Dr.
Did he
Rausch,
testify that this surgery was causally related to the accident?
Dr. Rausch, yeah,
Yeah.
he did. But that's the point.
So the jury rejected that testimony.
That's correct. And why did they reject it? Because 3 other doctors testified that there was no other correlation between the fall and the pain and the neck issue. And they correlated that by looking at the before and after images. So,
So are you saying that as a matter of law, Dr. Rausch's testimony would have been insufficient to find that the surgery that he did was causally related?
not as a matter of law, Your Honor, as a matter of fact. That's a question for the jury. See, the jury.
Based on Dr. Rausch's credibility as assessed by the jury.
Well, yes and no, and here's why. Anytime there are multiple doctors testifying and have different perspectives, the question is, credibility absolutely is always going to be a factor in evaluating the issue. But I'm going back to the most significant, I respectfully submit, issue, and that is there no reasonable possibility, or is there a reasonable possibility that the jury reaches this verdict, even if we take the Salazar issue out of the equation? And the answer is absolutely. Because if we take this entire issue out, and even if the court presumes that it was improper for the trial court to allow it, we should still look at the multitude of areas where Dr. Rausch's credibility was assailed based upon his findings and upon his lack of knowledge about the history of the plaintiff. And that's why I was focusing on that. Dr. Rausch testified that he looked at an MRI and said, I have concluded that the plaintiff has suffered this injury from this fall, and therefore I'm going to operate on it. And then when he was confronted with the fact that he had never looked at the prior images, he admitted it. And then he said, and he would defer to those doctors who did, as it pertained to the fact that there was no difference.
Are you saying he really admitted I only evaluated his after condition?
Correct.
Not his before condition?
That is correct. Well, but that's the interesting thing, because in his testimony, he tried to draw a contrast at first between the before and after, because he tried to testify. In fact, he did testify that this fall exacerbated the condition. But then when he was confronted with the fact that, well, in fact, Dr. Rausch, isn't it true you never examined the prior images? He said yes. And then when he was confronted with the fact that we had at least, I believe it was 3 different physicians who all did look, including his own, by the way, including plaintiff's own doctor, who all looked at the before and after images and said, I'm comparing these images and I see no difference. When Dr. Rausch was confronted with the fact that other doctors had testified that there was no distinction between before and after images, including images taken 2 weeks before the incident, because as your honor saw, the plaintiff had a history of cervical issues. He had a prior fall, he had a prior accident, he had prior surgery, he had a history of cervical issues. He was treating for cervical pain as close as 2 weeks before the incident, and Dr. Rausch said he was asymptomatic. If that's not a credibility destroyer, quite frankly, with respect, I don't know what else it would be. You have a physician comes in and says that the plaintiff was asymptomatic before this incident. And then he's hearing that 2 weeks before the plaintiff is complaining about neck pain with a 5 out of 10 pain, where Dr. Rausch admitted that that's substantial. The jury had plenty of reasons to reject Dr. Rausch's credibility, and that's the reason why they did. By the way, I wanted to make sure I point this out for the court. It was Dr. Melendez-Dedos, to be respectful to the full name, Dr. Melendez-Dedos, Dr. Nagin, and Dr. Cologne. Each one testified that the before and after MRIs were, quote, identical, unquote, and showed no changes. That's at the record at 1366, and at the transcripts, pages 303, 688, and 689, 692, 699, 711, and 730. So the record and the testimony presented to the jury was clear on this issue. Dr. Rausch admits at the transcript at 408, 412, 428, and again at 430 that he never reviewed the before MRI from his closest couple of weeks before. It was April 2021, so a few months before the accident. Dr. Rausch, when confronted with medical records showing pre-incident complaints, he admitted that he would defer to the providers who made those records. That's at the transcript at 433 and 435. And he admitted that the plaintiff's pre-incident neck of 5 to 10 was abnormal. And that's at the transcript at page 435. The point is,
Did Dr. Rausch provide then, I understand what you're saying there, counsel, but so then I'm trying to figure out how he tied his testimony to a conclusion of being causally related. Did he say that there was some medical reason not revealed by the lack of changes in the MRI that still made this reasonable and necessary to do the surgery?
I do not think so, Your Honor. I think, quite frankly, when he was confronted with these prior findings, he just acknowledged them. And I don't believe that he did, in fact, say, well, that's because, I don't think he did that, Your Honor. And once again, I believe that would be a question for the jury to evaluate, having heard all of the things that.
But the question for us, and your argument is whether then we can, by evaluating all the evidence, come to the conclusion that there is no reasonable possibility that this improper impeachment affected the verdict.
It goes back to, once again, the discussions that you were having, and I think it was Judge Mize who said, what is the cutoff? At what point do we get to the point? Right? Is it 1 versus 50? Is it 1 versus 10? That's what the totality of the evidence is all about. And I think that's where ultimately deference to the verdict should lie. If this was a case where there was no other issues of Dr. Rausch's opinion, and all of those things I just went through didn't exist, we'd be having probably, at a minimum, I'd be acknowledging it's a different conversation. But we're not in that situation. We have a circumstance where there were so many variables that undermined Dr. Rausch's opinion that the jury didn't even have to consider this other issue. And I do want to cite some cases because, the concept of harmless error analysis, once again, these are not from this court, so they're certainly not binding, but I would certainly ask the court to look at these if you haven't already. Walters versus Beach Club, the 3rd District, and these are all in our brief, of course. Although the trial court improperly admitted bad character evidence, it was harmless in light of the totality of the evidence. Rodriguez versus State, 3rd District, an isolated comment of an expert in the context of an entire 4-day trial was harmless error. And the court should avoid engaging in analysis that looks only to the result. In Bowley Centers versus Vines, the first district said, when examining the appellate record as a whole, the improper consideration of medical opinion testimony was harmless under the special standard. At the end of the day, the special standard did not create this insurmountable obstacle where this court should never affirm if there was in fact an error. The question is there a reasonable possibility that the jury would have reached the same result even if you took this out? And I would say absolutely, because I have all this other.
Can you repeat that line you just said?
Sure. When we look at special
I think
is,
you said the question is whether there's any reasonable possibility the jury would have reached the same result. I think it's the opposite.
it is the opposite, Your Honor.
Reasonable possibility that the jury would not have reached the same result.
It is, Your Honor. I was just looking at the corollary, and so when I look at the corollary, to be clear, I would submit, the question is there a reasonable possibility, no reasonable possibility this contributed to the outcome? And I would say, absolutely. I mean, in other words, you would get to this outcome even if this issue didn't exist. So therefore, when you look at the totality of the evidence, not just one little isolated incident, and use that and quite frankly, Mr. Harris candidly acknowledged we had a very strong case. And when you have a very strong case, then you look at the totality of the evidence and you say, the jury reached this result, and there is a reasonable possibility. There's a strong, I think, quite frankly, an extraordinarily strong possibility that Dr. Rausch's credibility was damaged, and more importantly, and not because of the Salazar order, but because of his own lack of information about this issue. And you have the other testimony that reinforced it.
And counsel, you would
Yeah.
agree if any number, the $5,000 numbers and then the zero numbers, if any of those, if we conclude that there's a reasonable possibility that those would have gone up by $1, that meets the special standard?
I don't think so, Your Honor. You know
No?
why? Because because that goes
That
to,
affects the is there a reasonable possibility it affected the verdict? Verdict will be different if it was different by $1, wouldn't it?
I understand the point.
Didn't
But
say
he-
significantly affect the verdict, it said affect
So
the
let me,
verdict.
so let me answer it differently. I think that to engage in that level of speculation, Your Honor, would require the court to look at this instance in.
Let me give you a more concrete
Sure.
example. Again, using as I did for your opposing counsel, $71,000 surgery. So this person, you agree he's the only one who testified as to that's the reasonable cost for the surgery?
Yes,
So this person who testifies to this in front of the jury under oath, and then the jury is told, and essentially gets in a conviction for a false statement, even though it is not a conviction. You would agree, in your experience, counsel, would you agree that jurors generally don't receive people who get impeached with felonies and statements of dishonesty, that those witnesses normally, to the extent you can tell, if the plaintiff, for example, on a negligence case, have you ever seen one get impeached with a felony conviction and never seen a plaintiff's verdict on one of those cases?
Your Honor, if the answer, I understand the hypothetical, and I understand that this is a damaging piece of impeachment.
A judge found somebody to have lied.
Understood. And
I would hope that would be a damaging. Doesn't our
understood.
system sort of hang on that?
Well, so, and this goes back to, again, Judge Boots's points, and it was a very brief reference, one question and one reference, or maybe one and a half in closing, so to speak, because there was a noted objection.
And very briefly, we're informed somebody was convicted of some felony dishonesty. We say, well, it was just a quick conviction.
It's not,
We just said he's a convicted liar.
it's
Doesn't
not,
the nature of the thing matter as much as how much time you spend on it?
Murder, capital sexual battery,
Yeah,
the jury gets word of that.
The more,
What happens
the
then?
more egregious the item, the less time you have to spend on it for it to be, meaningful to the jury. If they just put in, oh yeah, he's a serial killer, right? You probably wouldn't have to mention that more than once, more than for a second for it to really matter.
I understand again the point, all right? And I still believe.
Well, let me skip those.
Sure.
Yeah. So $71,000.
You should probably let him answer.
$71,000. We do know, there is no reasonable doubt that this jury did not accept his testimony on that number. Right? Now, the reason for it, as to whether it's harmless, can we conclude? So I use the $1. Do you think that well, if they would have awarded half of that, would you think that would meet if we can conclude there's a reasonable possibility that but for this improper impeachment, they give them half?
So I do not think that the court can conclude that. In other words, I will accept the
Because of the
premise.
threshold issue
Right.
that you mentioned,
Sure.
that it's really not, there's no reasonable possibility that they would have found that this surgery was reasonable and necessary and causally related by this accident.
That is correct. And I accept the premise of your Honor's question, but I submit that in this case, with the overwhelming facts presented in this case, all of the doctor's testimony, all of the evidence, and all of the other reasons why Dr. Rausch's opinion was not credible, not having nothing to do with Salazar, but having to do with his lack of knowledge about the information and the MRIs. That is the reason why there's no reasonable possibility that this one issue had anything to do with this verdict. So in light of that, I would respectfully ask this court affirm in entirety, unless there are any further questions. Thank you.
Thank you very much. Briefly, I think the discussion of the harmless error test, it's unintentional by my distinguished colleague on the other side, but the focus is on them and establishing no reasonable possibility that this contributed to the verdict. It's not,
Do you agree with counsel's assessment of the evidence and Dr. Rausch's concession that the before and after, he didn't see any difference and he deferred to the other expert?
Well, so the deferral was I defer to what's in the medical records, reporting of the symptoms. Just one little bit of clarification. He did testify as a before witness by saying that the condition was degenerative and asymptomatic. Now he's impeached, properly impeached in the cross-examination, but you didn't have these records. But he was not, but by testifying that this was a degenerative condition and that this caused the need for the surgery with the aggravation. So it's not strictly an after. I just wanted to clarify.
But with that, I guess my point is his assessment of the before was not based on personal knowledge and therefore couldn't be based on his credibility because he admitted, I just read this. Right? So at least for his assessment of what it looked like before, and therefore whether there was any change, right? It's not just that his credibility was impeached. His credibility was removed as an issue because he admitted he had no knowledge. He just said, this is not I just read this.
Right, and he deferred to my time is up, so I don't want to, he deferred to the medical records, but he did not withdraw his opinions on causation in cross-examination. He did not obey.
I'm not saying he withdraw his opinions. I'm saying he admitted his opinion was based on no personal knowledge whatsoever.
That is true, but he did not review the prior records informing his opinions.
Right, so his
percent.
It was based on records and things the other doctors said that the jury had equal access to with him. And his credibility as to the before part just wasn't an issue because everything he was saying he read, the jury could read, right?
That is correct, but the jury, mind you, did award for some of the past meds, and I know that gets to the question of, if there's any possibility that has the defendant established, in essence, there's no reasonable possibility that this devastating issue of impeachment, that affected contributed to the jury's decision to not award for that surgery. I would submit that test is not there. It's not an insurmountable test. I do not want to give that impression, but the test is a demanding test, which respectfully was not met here. I'm way over my time, but if the court has any questions, I would just obviously respectfully ask this court reverse, and if this court does reverse, I would ask that the remand instructions be only on damages and not in the liability issues, that we would not have the burden to have to retry the causation of a single loss, injury, or damage. But that's
All right, thanks.
Thank you very much,
counsel, for your arguments. Thank you very much.